departments. Is there any dissent? Senator Grady McLeod? All right. And we see public comment coming forward. So the organic nature of public comment.
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen. I'll be very brief. The Secretary doesn't object to the committee's action today to loan the $10 million for the Victims of Corporate Fraud Compensation Fund. However, we did want to alert the committee to recent developments that may impact our need to request those monies back sooner than later. Last Friday, our office received 500 claims, which is absolutely unprecedented. In previous years, we've received well under 25 claims in any given year since the fund's inception. Those claims, the 500 claims that we just received last Friday, are still under review. This could be a several months process in determining if there are any deficiencies, providing the claimants an opportunity to cure, and then finally analyzing whether they are entitled to the claims. But again, just wanted to make sure that the committee was aware that this could require us to come back and seek monies from that $10 million that's being loaned sooner rather than later.
And you understand that there's language in the trailer bill that allow you to do that?
Correct. Again, just wanted to make sure that the committee was aware of that.
We are aware, and we look forward to your vigilance. If there's a problem, you'll let us know.
Great. Thank you very much.
Okay. With that, if there's no dissent, we'll record the vote-only items as 2-0 with Senator Harmon not here, which will take us to the discussion items. And the first one is 0971, the California Alternative Energy and Advanced Transportation Financing Authority. That's on page 2. And we're honored to have a distinguished guest with us tonight.
Thanks, Mr. Chairman. The legislature earlier this year expanded the scope and authority of the commission which I chair, the Alternative Energy Advanced Transportation Authority, and its role essentially is to try to facilitate the expansion of manufacturing facilities in the state of California by permitting the waiver of sales taxes on new manufacturing equipment that would be things like electric car, solar energy panel manufacturer, and so on. We're contemplating a necessary ramp up to process regulatory efforts to get the thing up and running, and then to process a lot of, we anticipate, a lot of claims or applications by businesses that would wish to receive the benefit of those waivers. As you know, it basically takes about 10% off of the price of the equipment to not have the sales taxes apply. So the disputes or the issues seem to be of two sorts. One is, how much staff do we need? We're requesting 6. Now, we're starting from 0 with this program and think we need 6 to get it going. It's a loan that we're hoping for. Then the second issue was how many do we need, and then from where should the loan come? Is it a general fund or energy commission or some other source? We're sort of agnostic on the latter point. They may have views about what they think about that, but it's one that we'll deal with whatever banker you give us, and so those are the two issues, Mr. Chairman. I'm happy to comment on them further if you wish.
Well, the staff recommendation, which I just got, that I've received, I assume sometime sooner, was to approve the LAO's recommendation, but with 4 positions rather than 6. So it's the difficulty, I think, in just figuring out. It's always nice to argue with the treasurer, or not argue, but work over 2 positions in this small mom-and-pop organization, or try to figure out what the right amount is. So given that this is a new program and that a lot of this technology is new, getting the right number, we want to make sure you have the right number. But it's the porridge question. It's got to be the right temperature. So do you have any response? Is 4 good enough?
Thank you, Mr. Chair. Tiffany Roberts, LAO. Our analysis was basically limited to the funding source. I think we do concur with staff recommendations, though, on the staffing level. We were, however, concerned about the current fiscal stress on the general fund, and as such, we are recommending an alternative funding source, the Renewable Resource Trust Fund, which does have a healthy balance and could sustain a loan of this magnitude.
So as the treasurer said, he's agnostic on the, so you're fine with that. It's just a question of it's 4 or 6, and can we sustain 6? Yes?
I noticed in the, at least committee staff analytics, some comparison to the Film Commission that does tax credits for films. So maybe it's worth mentioning at least 2 differences. One is they have an existing agency with 8 staff people, and so they added some to their numbers. Was it 3? 3. We're starting at 0 and think that maybe 6 is what we need. The other point is our burden is a lot more complicated. We've got to figure out to what extent do these machinery investments eventually result in net benefits to the state, what kind of employment will come from it, whether it reduces greenhouse gas emissions, and some things that frankly are pretty complicated compared to just an automatic credit that goes out the door if they certify that 75% of their filming is done in their filming days is done in the state of California, things of that sort that are much more mechanical on the Film Commission. You know, I don't know how much the exact amount is. I don't want it to fail because we didn't do the right work at the front end. And the result, because there'll be a lot of pressure, is crony capitalism. If I can't create a mechanism that does objective analytical work, then it'll just be friends. And I don't want to do it that way. That's the risk with these kinds of programs is they become too political.
Understood. So my recommendation would be that we approve the funding source, but with 6 positions. Is there any dissent to that? And we will trust that if you don't need them, you will use that wisely or return it to us.
These days, it frequently takes 8 months to hire anybody, so there may be savings anyhow on the front end.
So that would be the motion. Any dissent? Okay. All right. Thank you.
Thank you very much.
Don't everybody get the idea that you're going to get what you want when you come here.
I'll try not to come back.
Only the treasurer. All right. Next item is 9100. This is a tax relief discussion, which is on page 3. And we will hear from our much esteemed LAO expert on local government. Hi, Marianne.
Good afternoon, Marianne O'Malley from the Ledge Analyst Office. The question before you is whether to continue to use general fund for this backfill for realignment programs. In light of the state's fiscal difficulties, we're recommending approval of the administration's proposal for general fund savings of $11.9 million.
Anything from finance? Anything from the public? Good afternoon.
Good afternoon, Mr. Chair, members. Jean Hurst on behalf of the California State Association of Counties. We oppose the recommendation in light of the governor's proposal and additional discussions on realignment. Maintaining that 1991 funding structure and the commitment that was made then is critically important both to counties and to the people we serve.
Judith Regal with the County Health Executives Association, also in opposition. Our members are the local health department directors. Our programs, public health and indigent health care, are primarily funded with the VLF funding stream and realignment. These revenues have been down, and we're already cutting services because of that, and this would basically result in additional cuts to those services at the local level.
Thank you. Marion, do you have any response to the public comment? I mean, I understand this is not a choice we'd like to make.
It is completely correct that these are funds that go to realignment, and as a result, cutting $12 million would reduce realignment programs. The question is basically the legislature has chosen when they implemented a change in the way that trailer coaches pay fees into the vehicle license fee fund, the realignment fund suffered a loss, and the legislature elected to reimburse the local revenue fund for those costs. And that was a decision made during much better fiscal times. Now, in light of the current fiscal situation, that choice to continue to backfill the realignment fund looks like a very difficult choice to maintain. And so we're recommending, in light of the fiscal difficulties, not backfilling this fund with nearly $12 million worth of general fund. But they are completely correct. This is realignment funding, and it would reduce the ability for counties to provide realignment programs.
Okay. Any questions or comments? Staff recommendations to approve the LAO's recommendation, and regretfully, I don't see where we have a choice at this point. So we will approve the staff recommendation 2-0 with Senator Harmon not here. Commission on State Mandates is next, which is on page 5 through 10. He's not going to be here. If that's your choice, we'll find out. All right, who's going to begin? Elio?
The next item has to do with the mandate reimbursement process mandate. Last year, you may recall, the legislature took a series of actions to suspend or repeal many mandates, bringing the annual cost for mandates down to a little over $100 million. There's this one mandate called the mandate reimbursement process mandate, whereby the state reimburses locals for the cost of going through this mandate reimbursement process and filling out all the forms. The legislature was concerned regarding the high cost of it and directed the Department of Finance to do a study this year and to come back with some recommendations for reducing the cost of the mandate. The Department of Finance indicated in April of this year that it was getting some more recent data and it would like to have some more time to be able to prepare a report. They also suggested that the legislature suspend this mandate in the budget year 2010-11 to avoid incurring cost in 2010-11 of about $20 million. Given that the Department of Finance has some additional data and want to take a look at this mandate, we think it's reasonable to give them an extension. We would request, though, the Department of Finance you may want to direct the Department of Finance to consider giving you this recommended solution in January so that you'd have some time to consider it. So we'd recommend that if you extend it, to not extend it all the way to April. It's very difficult to absorb a significant change in policy change in April. The second thing is, in terms of the suspension of the mandate, we continue to be concerned that it's not really fair to locals to mandate that they go through this elaborate process to get their mandate reimbursements, but then not fund them for it. With the understanding that the administration will come back with a proposal for revamping this mandate reimbursement process mandate, we would reluctantly concur with the administration's proposal to suspend it for just one more year.
Okay. Finance? Or the administration?
We have no significant concerns with providing a report in January.
Okay, good. Any comments from the Commission? No. Public comment?
Hi, Mr. Chair. Jean Hurst from the California State Association of Counties. I think we are concerned about the suspension provisions. For all intents and purposes, if we suspend the process by which we are to get a mandate claim filed, we are left with literally no opportunity to do anything during that year. Does that push us to the courts? I don't know. But it certainly creates a great deal of uncertainty in terms of what we're supposed to do during that time. And so we're very concerned about moving down the road to suspension on this specific mandate.
Question for Marion and the LAO. given the severity of the times, and is it easier just to suspend without going? I understand that we want to make sure a suspension is a suspension, and that's part of what we're trying to do. Is just coming from local government. You know, you have a mandate. It's a problem to go through. You don't have the money for it. Just suspend the mandate. To some degree, we did this with education last year, where we allowed them more flexibility, knowing that we were taking their funding away on some of their categoricals. So forgive my ignorance, but how do we get to something like that in these extreme circumstances other than to go through the recommendation and the process? Is there another way? No.
The mandate reimbursement process reimburses locals for two things: the cost of the test claimant who proposes a claim to the commission. And unless we're going to substantially change the commission process, those legal costs associated with it are unlikely to be changed. The other portion of it is the cost of compiling all the paperwork to file a mandate claim. And with any luck, the Department of Finance will come back with some kind of alternative or some kind of way of reimbursing local governments for those costs that are somewhat less than they are now. The concept of suspending this mandate is kind of awkward. This is the only way that local governments can get the reimbursements that they're constitutionally entitled to. So to say that the process is optional if you wish to get your constitutionally entitled reimbursements is somewhat awkward. What we were hoping for is the Department of Finance to come back with some kind of a proposal, maybe a unit cost proposal or something that makes local government's job of filling out all these forms a little bit easier, and therefore to reduce the cost.
Yeah, I was thinking just, maybe even simpler as you suspend them. If there's a historical mandate, I guess is what I'm thinking of, but maybe I'm misspeaking. You're not going to have the funding, you just suspend the mandate. Similar to my analogy with Prop 98 funds, well, not Prop K through 12 funds, is if we're going to give you less money, we suspend some of the requirements for special ed or adult education for a year, and then the local district can decide it's more fungible. That's sort of where I was going.
It might be if the Department of Finance could work with local governments to identify the provisions of the mandate reimbursement process that are the most expensive to comply with. They could come back with a proposal for restructuring this mandate so that there's lower cost.
Okay. Well, we hope you be creative and sympathetic with local government. How's about that? You get a sympathetic comment. That's priceless. All right. So with that, the recommendation is to approve the May finance letter and the recommendation from the LAO. Is that correct? Hearing no dissent, take us to the next item.
Yeah. The next item
2 is open meetings and the Brown Act.
Yeah. Is a mandate that has been quite sensitive over the years. It's called the Open Meetings Act and Brown Act mandate, and I've got a handout on it for you just to give you a little bit of background. The first thing that's important to know is that the core provisions of the Brown Act and the Open Meeting Act, they're not mandates. They were enacted in 1953, that long predated mandate law. So the general core provisions of this act, the requirement that you have open meetings and such, that is not a reimbursable mandate. The pieces of the Open Meetings Act, Brown Act, that are reimbursable are the components that require local governments to prepare an agenda and post that agenda 3 days ahead of time, and after coming back from an executive session to reopen and to discuss what was the content of the discussion during the executive session. So you could see on the bottom of the page 1 of the agenda of the handout, agenda preparation is reimbursable, agenda posting, closed session disclosures, and then on the next page also training your local officials regarding compliance with those provisions. All of that is a reimbursable mandate. The cost of this mandate for the non-education side is something in the range of about $17 million a year. But for a variety of reasons, there's only a small amount of bills that are due and payable in the budget year, and that's less than $400,000. In terms of what, just to give you a sense of what actually local governments claim for, I had some examples that date from 2001 to 2001-2, because that was before there was a legal skirmish regarding this mandate. So that's kind of the last bunch of data that we have in terms of local government claims. You could see that local governments charge about, the first was about $3,000 per board meeting. In order to prepare the agenda. In the county of Kern, they claim 30 minutes per agenda item in terms of what their costs were. So that gives you a sense of what they're actually getting reimbursed for. It's the preparation and posting of the agenda and the staff time associated with that. In the May revision, the administration proposes to suspend the mandate. So that would mean that these provisions, the preparation of the agenda and the posting of the agenda and the announcement of the actions taken during executive session, that would be optional under the administration's proposal, as you're suspending the mandate, and so therefore those provisions would be optional. You'd still have the broad requirements of having open meetings, but the agenda posting 3 days ahead of time, that would be optional. If you turn to the last page of our handout, you'll see a little bit of a description of Prop 59 of 2004. And you may remember this is a constitutional measure that embodied a lot of the spirit of the open meetings law, and it says that people have the right to access of information regarding the conduct of the people's business, and it provided broad public access provisions. Prop 59 doesn't directly address the Open Meetings Act, but certainly components of it are integral to carrying out Prop 59. In terms of the LAO recommendation, this is what we would suggest. Remember that the Constitution doesn't require the state to reimburse for voter-approved mandates. It only requires the state to reimburse for legislative or executive imposed mandates. You could amend the Open Meeting Act law to specify that local agencies must annually announce at a hearing how they're going to comply with Prop 59. And you could say that they must announce how they're going to comply with the provisions of Prop 59, and that the standards of the prior law, the Open Meetings Act, Brown Act law, would be reasonable guidelines, that they could comply with that. If they elected, if they did not wish to comply with that, they need to annually announce their alternative policies, and they need to comply with Prop 59, and they need to be rigorously followed. So it would give local governments a choice of either following through with these Open Meeting Act requirements or something else of similar magnitude. By restructuring this mandate to give local governments the option in this fashion, it would eliminate it as a reimbursable mandate. And on a going forward basis, the state would not be required for reimbursing this as a mandate.
Do we know, in terms of the actual costs, has anyone ever done a study? I hate to be so anal, pardon the expression, but again, coming from local government, I can't imagine it costing $1,000 just to prepare a agenda item. Is that a whole staff report?
What local governments usually say is that their agenda needs to be reviewed, say, by their city manager, by their city attorney. It needs to have some clerical time, needs to have a piece of the computer printer, et cetera. And so they prorate it out. And so they charge for the full cost of the agenda preparation, oftentimes per item. And that's why you end up with cost of, between the local government and the school side, of something in excess of about $20 million a year.
And is it the expectation that local government will just stop posting agendas if we approve this?
If you would approve the recommendation, my sense is that many local governments would continue to comply with the Open Meeting Act guidelines as being recast under this recommendation. As an alternative, though, a local government could announce at a public meeting their alternative policies for following through with the spirit of Prop 59.
And if they don't, there's some legal ability for a citizen to question whether they're complying with Prop 59.
Yes. And you could specify a penalty in there if you wish.
So local government would actually, if we didn't do as you recommended and just said that we're not able to reimburse you for this, are we capable of that?
Well, you've got a variety of options. You could adopt the administration's proposal and suspend the mandate, okay? When you suspend the mandate, you make the provisions, the mandated provisions, optional, okay? And that works for 1 year unless you were to suspend it again next year. The concern that our office has with that approach is suspending mandates is frankly very confusing. People don't really know how a suspended mandate works, and they would pick up the codes and they would think that there was certain things that were required, but they would pick up the Budget Act and they'd say, oh no, those provisions have been suspended. But that is one option. You could suspend it, and the legislature has suspended many mandates in the past. So that's one option. Your other option is to fully fund the mandate, and over the long term, your cost for this mandate, it would be about $20 million a year, okay, including the education side and the non-education side. So you could suspend it, you could fully fund it, or you could revise it to eliminate its reimbursability, and that's what our suggestion is.
And I'd say just pursue, and I appreciate everyone's tolerance on this, but I think this is actually pretty important. Sort of the basic premise of local government and government in particular is to make sure the citizenry is alerted to the most simplest thing, which is the agenda for the governing body. So could we take sort of a hybrid and eliminate the provisions around education, just say you have to continue to post the agenda for publicly noticed meeting?
I'm sorry.
Go ahead. And what might be the consequences of that fiscally?
The training components, if that's what if you're referring to the training that's on page 2, that reimbursability, it's the training for the local government staff about how to comply with the Open Meetings Act. And that's sort of a necessary component of any mandate, is making sure that you're training the staff and how to follow through with the law. The problem is, before we had the Open Meeting Act, I suspect most local governments had agendas, and most of them posted it. But when you make it a mandate, the full cost of it becomes reimbursable.
Okay, so your expectation is most governments will continue to do what they always did. Most
would comply in the same fashion that they have done before. There may be some local governments, though, that would during a duly public meeting, announce alternative policies for providing broad public access to their agendas and their meeting materials.
Okay. Senator Grady-McLeod.
But like college boards, they would still have to publish an agenda, because their board members have to have an agenda when they're working on whatever it is, and so they'd have to have an agenda there at the meeting for the public that would attend that. And I imagine for city councils it would be true that they'd have to publish. Otherwise, you just don't have an agenda and you're just sitting there chatting.
Which we do that with an agenda, so it would be really bad if they didn't have an agenda.
Your point is correct. Before there was a requirement for doing an agenda, most local governments, most governmental organizations, most private organizations prepare an agenda to figure out how best to organize the governing board's deliberations. So before we had the Open Meeting Act requirement, most of them were doing agendas anyway. And I'd suspect that even if we were to revise this mandate, most would comply with something very similar to the Open Meetings Act in the future. But if you require that there be a mandate, if the state requires that there's a mandate, the state needs to pay for it.
Anything else? Anything from the Commission?
Paula Higashi, Commission on State Mandates. I just wanted to add that the system for reimbursement for this mandate does include unit costs. The unit costs were based on studies done by local government as to their actual costs claimed. And so a sample was used, and numbers were calculated, and the rates were set. And so those numbers have not been revisited, or those times, since the time of adoption.
Do you know when the study was done? And
I was just looking.
With all due respect, we relied on the information from local government.
I didn't happen to bring the documents with me on that.
All right. Finance, do you have anything?
I'll get them to
Okay,
Brian.
that'd be helpful.
Okay.
Anything from finance? Nope.
No objection to the LEO's recommendation.
Any public comment? It's not agendized, but we'll allow for it. Okay. Well, I guess we'll support the LAO's recommendation. I'd love to see that study. Maybe the local government that I was on, the multiple local government agencies were incredibly efficient.
Or could have driven up the cost, too.
Or could have driven up the cost, too. All right. So we're adopting the LAO's recommendation. That's 2-0. And we're putting faith in local government to do the right thing and keep agendizing, as they always did. Issue 3 is the April finance letter on in-home support services mandate. And who is going to, the Commissioner, LAO, comments? Thank you for always being the voice of reason and experience.
You may remember this from one of your earlier hearings, and the key question associated with this mandate is, does the committee want to fund the mandate's prior year cost in order to continue the policy in the future? Because remember, the state has to fully fund a mandate if you want to continue the activities on a going forward basis. This mandate has 2 provisions. Counties have to form IHSS advisory committees. The Commission ruled that the cost of running these advisory committees, these IHSS advisory committees, above and beyond certain state reimbursements that they got, was a reimbursable mandate. And counties also have to identify an employer of record. The Commission found that those costs, which are probably one-time only, are reimbursable. The county claims were $475,000. The governor's budget proposed to suspend the mandate, as they have proposed to suspend almost all non-public safety mandates and allow the state to defer that $475,000. Then the Department of Finance issued a finance letter suggesting making the advisory committees optional, but fully funding the mandate, the $475,000. Our office has recommended kind of a hybrid. We would suggest that you approve the Department of Finance's proposal to make the advisory committees optional. It seems like local governments could decide what forum they want to discuss IHSS affairs in. So we'd recommend approval of the legislation to make the advisory committees optional. In terms of funding the mandate for the employer of record component, we would recommend the legislature fund it. However, you could fund it by redirecting certain funds that are currently used for IHSS advisory committees, and that would have no net cost to the state.
Finance, do you have anything? Ms. Spoon, your recommendations.
Jeff Carasone, Department of Finance. We continue to support the proposal to fund the $475,000 out of general fund, redirecting from the IHSS budget. It's a little unclear. It could result in a loss of federal funds. So we're continuing to support the general fund augmentation of $475,000.
So staff recommendation is approve the $475,000 general fund augmentation and do not suspend the mandate, and to take no action on the administration's trailer bill, which is in the purview of Subcommittee 3. So as they continue to discuss this particular item and as IHS continues to be a discussion amongst others, it'd be my recommendation to follow staff's recommendation. And that will stand as 2-0. The last issue, issue 4, mandate redetermination process.
We had a little bit of a discussion, you may recall, at one of your earlier hearings. Under current law, after the Commission makes a mandate determination, there's no legal process to have the Commission update that determination based on subsequent changes in facts, laws, or circumstances. Over the last year, the Department of Finance, our office, and others have been working to develop a new process, and a couple weeks ago we invited the local representatives to join us in drafting some legislation, and we're very close. The version that you have attached to your agenda represents there's 2 substantial changes since the last time we discussed this proposal. The first change is that the Commission would go through a two-step process. The first process would be to determine whether or not, in a case of a particular mandate, there have been any substantial and relevant changes in mandate law. And if, in fact, they find that there have been some substantial and relevant changes in mandate law, they might redetermine a mandate. So it will be a two-step process to determine whether or not a mandate decision would be reconsidered. And then secondly, we created or proposing a statutory process for the legislature to voice its interest in having a particular mandate decision redetermined.
Okay. Any other comments from the Commission or from Finance? The public? Jean?
Once again, Jean Hurst on behalf of the California State Association of Counties. As Ms. O'Malley mentioned, we did participate in a meeting. I think we still have some concerns that we'd like to see addressed, and we'll continue to work with the working group to address those issues.
Okay, great. The recommendation is to approve the placeholder trailer bill language and to wish you all continued success in making the mandates as clearer than mud. That's 2-0. Thank you. That'll take us to Part B. We'll change staff. And actually, before everybody gets too comfortable, we've had a request to change the agenda so managed healthcare could go first. Sorry. Consumer Affairs, you can investigate managed healthcare as to why they have to leave so quickly. But we're not going to give you any staff to do that. This is 2400, the Department of Managed Healthcare, which starts on page 12. Welcome. You're in trouble with Consumer Affairs, but don't worry, they don't have any staff.
I know. Actually, I used to be an executive officer over at Consumer Affairs, so I have great respect for the work they do and really do appreciate that you're allowing us to go first. Thank you. Thank you, Chair. So we're here on the budget item related to our request associated with the BCP for ABX 49. And we're here because of the recommendations related to disapproval of this item. And so I thought it was very important that I come personally to talk about this because it involves not simply a budget item, but an area of focus that relates to tremendously substantive work the department is doing, and as well to some requirements in the law that we think it's really important at the outset that we have a clear understanding with this body about what its intentions in that legislation are and the expectations of the department. So I wanted to go back to that trailer bill language that related to the requirements on regional centers. It's found in Section 4659 of the Welfare and Institutions Code. And essentially, that language says that the regional center, a regional center, is prohibited from purchasing any service that would otherwise be available from private insurance or a healthcare service plan when a consumer meets the criteria for coverage but otherwise chooses not to pursue that coverage. Secondly, the regional center is prohibited from purchasing medical or dental services for a consumer 3 years of age or older unless the regional center is provided with documentation of a Medi-Cal, private insurance, or healthcare service plan denial, and the regional center determines that an appeal by the consumer has no merit. So essentially, there are obviously two impacts. One is, of course, on any service which pertains to any consumer at a regional center. The second relates to medical or dental services for consumers 3 years of age or older and involves essentially a two-step process there, and that is that they, in fact, have a denial from a health plan, and that they then have, that the regional center has gone through some understanding that an appeal would have no merit. So from those requirements, we fashioned our workload assessment based on some pretty complicated, and we felt at the time, conservative ideas about how this would potentially impact the department. And I will have our deputy director, who's in charge of our help center, go through those in just a minute. But from our standpoint, what we have right now is a situation where there is a clear budgetary mandate on the regional centers. It's my perception that at this point we're working with centers that have not been accustomed to doing these kinds of analyses. This obviously isn't in their job description heretofore, but it is now. It is now, in fact, an expectation of this body that they will, in fact, go through an analysis of coverage, and not simply a check-the-box process, which would not fulfill the purposes of this budgetary savings expectation, but in fact will go through a process which will be an iterative process in much the same way that any consumer right now, any enrollee of a health plan, goes through when they have a denial. So first of all, it will require that they will first submit that appeal to the health plan, and then the health plan would deny it. At that point, then, or permit it, but possibly deny it. At that point, they get a letter, that consumer gets a letter that outlines from the health plan the number for the California Department of Managed Health Care, and states their right to file an appeal as of that time. Now, normally in that process, heretofore, they may not have paid any attention to that language. It didn't pertain to them. Nobody was following up on that. Now, I think culturally and that from the standpoint of expectations, the regional centers backed by DDS will in fact be enforcing that requirement to read that language and to do something more. Now, that something more, as I say, involves contacting the Department of Managed Health Care. It involves first filing a grievance with an appeal with the health care plan, and then they receive notification of their right to file a grievance with the department. At that point, again, that triggers the obligations of the department to handle that complaint within a 30-day time period. So we have constructed these workload estimates based on what we think is a conservative analysis of how many enrollees are potentially impacted by that, and what, once the regional centers really get up to speed on what their requirements are, what we think that'll be. We now are not in the position to defend a current workload requirement for this. There's no question about it. But our job, really, in anticipating the needs of a very, very vulnerable set of consumers, is to ensure that the department stands ready to help enforce their rights to access their private health care coverage if, in fact, that coverage is available to them. We take that obligation really seriously. This is a big area of, again, substantive learning both for the department and a major workload growth in general around children with autism, and again the expectation of what kinds of services they should be receiving from health plans. So we are, again, as I said, here to suggest perhaps an alternative to the current proposal for the 9 positions. And that is to, and we have provided our recommendations to the LAO, and that is to recommend that we would request that you would approve the request as submitted, but add provisional language in the Budget Act that would provide a process for the department to confer with the Department of Finance before establishing the new positions, which would allow the Department of Finance to validate that there is, in fact, an increased workload that justifies each and every position that we would be adding. And this is the recommendation that we would ask for. We think, and I think as director of this department, that we have tried to be very judicious in the use of our resources, because we realize that every single time we add an additional item to that budget, that it impacts the cost of premiums, because we are self-funded through assessments on health care premiums. And so we take that very seriously and feel like we have done that, and feel like that warrants us asking for the trust that we will go forward in a judicious fashion to fulfill this workload as it comes up, but that we would do so in conjunction with Department of Finance, as opposed to alternatively ending up seriously behind the 8 ball. And again, that isn't just a minor concern that we feel bad about missing 30-day deadlines. That, in fact, means delay of services for a very, very vulnerable population. So for that reason, I felt it was important that I come today to ask that, and would then make available either of my staff, either Debbie McKinney, or Andrew George. I'm sorry, I forgot your name. So with that, I would respond to any questions you might have.
Questions? LAO, do you have any comments?
Thank you, Mr. Chair and members. Farah Brocht with the Legislative Analyst's Office. When you heard this issue last time, we recommended that you reject the request for the additional positions because the workload hadn't materialized. As you're hearing from the department, it still has not materialized, so our recommendation would be the same.
And I think the expectation, at least from the legislation, is that there would be cost savings. So you're saying there's startup cost. Do you have any idea within this population how many have insurance right now that might actually, and I know this has been a long discussion, and I understand just my own personal relationship with the local DD community. I know they're very passionate about their issues, justifiably, but there's lots of questions about what we can afford and what we should afford to do for the DD community. I'd like to give them everything they can, but we can't. So if you can buy health insurance that covers it and you can afford that, the idea, correct me if I'm wrong, is that that's something that people who can afford that and choose to do that, either for their family members or people who they're responsible for, that there would then be savings to the state. So the idea that we're trying to capture savings from people who already are paying for private insurance that will pay for this seems to me to be perfectly logical. And now you're telling us that's also logical, that there's a startup cost to that. So I guess the question is, does anybody have any idea how much money we might save by identifying these folks, and I hate to use that word, by identifying the clients, and when we might see some of those savings?
Well, first of all, let me just go back to the, as you discussed, the fact that this is a group of people who many times may have private health insurance. But there has been very little definition of what, in the broad range of services that these children need throughout their early years, and then obviously even through their lifetime, but particularly through their early years and getting to school, what part of those are really health care services versus what are educational services or some other form of social services. And so that definition, that absence of definition, has really meant that there are obstacles to parents applying to their health insurance for this coverage, and that has meant that they have pushed those costs onto the backs of the regional centers, and as has been identified in this legislation, improperly in certain instances. So that is the job that the department does have to do in conjunction with the regional centers and with DDS. Now, in terms of the savings that were expected, I thought that was...
I thought it was about 200,000 or 200 million at DDS that they were projecting as savings for the general fund.
Okay. Do you have any other comments?
We do not, unless you would like to know how we reached the calculations of the workload estimate.
Briefly, please.
Okay. Again, Andrew George, Assistant Deputy Director of the Department's Help Center. Again, in formulating our BCP, we met with representatives from DDS, determined that they serve approximately 240,000 consumers. Of that 240,000, they estimated that approximately 60,000 of those had some form of private health insurance. And then we therefore formulated our BCP based upon that number of 60,000. And again, I think it's important to note that we're only considering as potential complainants those consumers who are receiving services from licensed providers, because those are the consumers that are most likely to have services covered by their health plans, and those would be the services where the regional center would determine that an appeal to the health plan would have merit, and that's where our workload would then come in.
Okay. So if the department's going to save $200 million, you would think that they could absorb these costs.
We don't save $200 million.
I know, but that's what the analysis says. I'm just thinking out loud.
The Department of Developmental Services.
Mm-hmm.
Right.
Oh, okay. I just want to make sure. This is not, again, this is only an expense to us. We don't realize any savings. Okay.
Okay. Any other comments or questions? Well, with all due respect, I'd recommend we go ahead with the staff recommendations, which is to reject the request. We understand the pressure under. Hopefully you can empathize with the pressure we're under. Happy to continue to sidebar conversation as we go through the process to get a better understanding of the pressures on you.
Okay. All right. Thank you very much. Appreciate the time.
Thanks. That'll take us back to Consumer Affairs. Another non-controversial. All right. Welcome. Thank you for your patience and your graciousness. So we'll let you start off. Let's see. We've got vote only. That on the first item. Is that correct? First two items. Any consent on the staff recommendations? No. So that's 2-0, which will take us to item number 3, which is the Consumer Protection Enforcement Initiative. BCP number 1A. We've had this once. Welcome.
Good afternoon, Mr. Chair, committee members. Brian Steger, Director of the Department of Consumer Affairs. Consistent with my earlier testimony, Mr. Chair, this BCP is needed for our healing arts boards to investigate cases and prosecute cases better and more efficiently at the Department of Consumer Affairs. We are currently trying to reduce the time that it takes from an average of 3 years down to under 18 months. And this is the governor's initiative to help or to improve health and safety of California consumers. And I'm happy to answer any questions that you may have.
Any comments from the LAO? Nope. Finance? We've been through this before, but Senator Negrete-McLeod, I know something you have an interest in.
Mr. Chair, I'm going to vote today for the staff recommendation on reducing the number of the PYs because I know that the issue will get further vetting in the conference committee. However, I've introduced a bill this year to strengthen the enforcement program for the healthcare boards and bureaus, and it was clear that the bigger part of the problem was the shortage of investigators. On the other hand, we know that a portion of the backlog is due to, in part to the governor's decision to furlough all state employees, even those funded by the licensing fees and special funds. We know that the furloughs have created workload backlogs, impeded consumer protection efforts, and have actually cost the state money. I really do believe that the Department of Consumer Affairs needs more investigators, and I am concerned that 70 positions will not be sufficient. However, I will continue to work with the budget chair and the department to find an appropriate number to better protect California consumers.
And I would just concur. I think this is more of an issue of process, as you and I have talked about. As with Senator Grady McLeod, I think we realize the need and the need both to expedite the process and make sure that you get the backlog taken care of. But there is a process to bargain some things, both in this and externally, in good faith that costs us all some extra work and consternation. So the recommendation I would support as well.
Mr. Chair, if I...
Go ahead, and then but let me direct traffic between people who are responding to our comments, first to the department, then to finance.
I apologize, Mr. Chair. I would just respectfully ask the committee to reconsider the reduction in the number of staff. We're really concerned about if this does go to conference committee, we end up with 70 positions, then it really is going to be problematic for the department, and we're not going to be able to fix all the boards that we have. And so, certainly, if the committee needs more time to talk about this, we would recommend that the total amount of the BCP be reduced by about $1,000. We would respectfully ask that to be reconsidered.
I appreciate that.
Kristen Shelton, Department of Finance. My comments would have largely been along those lines, but just for way of consideration, the staff request essentially cuts the budget year +1 cost into half. And we already took or applied a phased approach that we think is a fair and reasonable approach. So as the department noted, a $1,000 reduction would achieve your objective to put the issue in conference. Also, we had shared revised trailer bill with staff that just is very narrow, applies only to 3 provisions. So we would hope that that could be adopted in lieu of the full trailer bill, which was also kind of closely linked to the policy bill, because it's critical to be able to hire non-sworn staff to have at least the authority in statute that says they can hire non-sworn staff.
And I appreciate both your comments and your efforts. Unfortunately, discussions we feel should have happened in other places, and hopefully there's still an opportunity. All right. So with that, it's 2-0 with our comments included as part of the record. Let's see. That takes us to our next item, which is issue number 4. And this is BCP number 1B, the Breeze technology. And let's see, staff's recommendation is that the subcommittee approve the proposal with trailer bill language requiring the Department of Consumer Affairs to receive joint legislative budget committee approval for the final contract before payments to the vendor can commence. And then staff further recommends that the trailer bill includes reporting requirements to DCA to examine the need for the DCA board's licensing positions after the system has been completed. Go ahead.
Mr. Chairman, members, Bill Young, Consumer Affairs Executive Office, we're fine with that recommendation.
Well said. LAO, anything? Finance? All right. So with that, it's a 2-0 vote. Thank you for coming forward. Issue number 5, private post-secondary education. This is BCP number 09L. And the staff recommendation on this item is to approve 60 permanent positions for the Bureau for Private Post-Secondary Education. Welcome back, I should say.
Thank you.
Any comments?
Pardon?
Any comments?
We just hope to get this approved so that we can actually get some staff and start regulating those private post-secondary schools.
Okay, good idea. Don't argue for the 7.5 position. Anything from LAO? Finance?
Jeff Carasone, Department of Finance. Just as a point of clarification, the approval of 60 positions, the request was 71 positions, but 67.4 personnel years, which takes into account salary savings. I'm just trying to figure out if the approval of 60 positions is of the 71 or is it of the 67.4?
So we'll make it 60 PY.
Personnel years?
Yes,
okay.
Thanks.
Thanks for the clarification.
Got to get caught up on my abbreviations. Is that okay? We clarified? So that's the recommendation. Seeing no dissent. Did you want to make?
Yeah, Pam Wortman, Deputy Director, Admin and Information Services. On the staff recommendation and in the proposal itself, we requested 60 permanent positions and then 12 LT positions. So I'm assuming that the recommendation is just not to include the LT positions?
Yes.
Thank you.
That's a good assumption. All right, any other questions? Want to make sure we're all clear. Yep. All right, thank you. Good luck. We wish we could give you more. Issue 6 is the Board of Behavioral Sciences, SB 788, Licensed Professional Clinical Counselors. Welcome.
Good afternoon, Mr. Chair, members. Hi, I'm Kim Mattson. I'm the Executive Officer for the Board of Behavioral Sciences. And this request before you is consistent with the fiscal impacts previously identified in SB 788, the legislation which establishes professional clinical counselors under the Board of Behavioral Sciences. The workload associated with this licensure program is comparable to other licensing programs administered by the board. The request before you reflects 5 staff for licensing and registration process, 3 enforcement staff to perform criminal background checks, an integral part of consumer protection, 1 staff for examination, development, and administration, and the remaining staff to develop regulations, conduct outreach, and educate potential licensees and consumers, and provide program oversight. I will note that 2 of the requested positions are for a 2-year limited term. Approving our request as submitted provides the board the ability to efficiently license qualified applicants, which allows entry into the California workforce and meet its statutory requirements. The board respectfully requests the committee's approval of this proposal as submitted.
Okay. LAO, anything? Finance, anything?
It depends if you're going to adopt the staff recommendation. I have a question about that.
I should have anticipated that. Any questions? The staff recommendation is to approve 5 positions. Your request is 6 positions in 2010-11, growing to 12 positions in 11 and 12. Is that right?
Correct. So the 6 positions would start in January.
And our recommendation is 5. Correct?
Mr. Chairman, the request is actually 12 bodies, 12 positions, but if they start half year, it's technically considered 6 personnel years. I hate to keep using that term, but it's okay. 12 people starting half year, so that equates to 6 personnel years. So I'm just wondering if the approval is 5 positions or 5 personnel years.
Positions, then.
Mm-hmm. So it's being explained to me 5 people. That's different from personnel years, is that?
Technical budgeting term, I apologize. Yes.
I just want to see how you view people, that's all. Since you're in behavioral sciences.
That can be a challenge at times, yes.
Right, that's why you need more support.
Oh, of course, yes.
So is it all clear as mud?
Yes, absolutely. And so 5 personnel years, 5 positions.
Yeah, please.
It would be 5 actual people not to be increased in budget year plus 1. So it's not P-wise, it's actual people.
Just so you know, I mean, that will limit the board's ability to meet the requirements in SB 788.
And we will hope that you will do the very best you can with the resources available.
Thank you.
So that's the recommendation. Any dissent? Thank you.
All right, thank you.
Yes, that's the end of Section B. Did you have a question on this one?
No, I don't have a question. I just wanted to say welcome to Stacy. That used to be I work on B&P in the assembly.
Oh, sure.
Yeah.
Well trained.
Mm-hmm.
You're welcome. This will take us to Agenda C. Hey, Brian. You okay?
He's talking there.
Our first item on Agenda C is a financial information system for California Fiscal, and it's on page 2, and it's item number 8880. Welcome.
Okay.
And this is so we're in Agenda C, Part C, page 2, Fiscal.
Okay.
Have any comments?
Okay. Good afternoon, Mr. Chairman, Senator Negrete McLeod. I'm Titus Toyama, the project executive for Fiscal, and with me is Janet Roseman, the chief of admin for the project. I'm looking at page 6 of your agenda, if you'd like for me to speak to the staff recommendations.
Mm-hmm.
Okay, thank you. As I understand it, there are several recommendations of staff that I'll take one at a time. The first issue involves the adoption of a review period for the legislature to review the fiscal proposal before we actually execute a contract. In the current schedule, as approved last year by the legislature, there is a 30-day review period during which the GLBC and ledge staffers and others can review the project's recommendation going forward, and only upon concurrence at that point would the project then sign the contract. I understand that the ledge analyst feels that that period ought to be longer, to 60 days, feeling that given the nature of this project and its high cost or risk, et cetera, but also the broad implications it has for the state, that it actually may take longer than 30 days for them to reach a recommendation as to the way the project should go forward. After talking to the ledge analyst about this recommendation, we can live with that. We can live with a 60-day review period. We understand that this is the legislature will have a major decision to make, and if it requires 60 days for them to feel comfortable with the project's way forward, we would just simply build that into our schedule and go forward with that in mind. The committee agenda, though, speaks to possibly having that period extended by another 30 days. Again, so going from 30 to 60, then to 90. And again, if that's the decision of the legislature, we can find ways to mitigate that risk. But as I see it, going from the 60 to 90 raises two concerns. The first concern is that the project is very focused on delivering the first parts of Fiscal system during the fiscal year 12-13 fiscal year. And so by having an additional 30 days as part of the review cycle, it narrows our window for implementing Fiscal and achieving that objective. The second concern is that the longer you have delays or waiting periods, there is a cost to the project, because prior to the time that the project would actually start working with the vendor, we would be incurring costs for keeping the project going, for staff, et cetera. And so, we can perhaps mitigate that, but that is something that we'd have to consider and build into our schedule. So our bottom line is that, we certainly respect the legislature's need for review time. We want to make sure that they're bought into and they support the project going forward. But there are risks from going from 60 to 90. And if the legislature does choose to adopt that longer reporting period, we would respectfully ask for a waiver process, so that if the legislature is comfortable before that 90-day period elapses, then perhaps we can sign a contract and move on.
Mm-hmm. Elia.
Todd Bland for the Analyst's Office. I think, as Mr. Toyama said, the LAO thinks a 60-day review period makes sense for a project of this scope. We really view that the result of sort of the bake-off process, this multi-stage procurement, whereby we're going to let 3 different vendors really work with the state and the state staff on what our needs are and give us 3 proposals and give us a prototype. We think that approach makes a lot of sense, but we also think that is the moment of truth. At that point, we really are going to have sort of the costs of the project will be in front of us, the benefits of the project will be in front of the legislature, and we're talking about, a multi-year commitment to substantial costs. So we think 60 days rather than 30. And we think that strikes a balance between giving the legislature enough time. We think 60 allows potentially, we don't know when this will come, although the anticipation is next summer. The legislature might even be in session. But if it weren't, it would give us the option of also even holding a hearing if the JLPC needed to do that. We think 60 strikes the right balance, and we can work with that. We would also urge and I believe we've had productive discussions with the project staff that they will be sharing information with us so that the 60-day review doesn't begin cold, so to speak, at least for the LAO. We won't spend the first week rounding up the documents. We'll have already be hopefully up to speed and ready to start our review right then.
Well, I just maybe suggest something in between that I think we want to be assured, given that the initial review is going to be up to a year, and as you said, this is such an important investment for the state, and I understand it's already been scaled down. And in the era of term limits where we've got members, it's hard to get enough institutional memory on something this complex, is that we do the 90 days, but if you can come to us in 60 days, then we can get it done. So sort of the opposite of what you're asking for. Certainly open to the discussion. If you need to get here and out of here in 60 days, we can do that. But that would still keep the option of the 90 days, as staff has recommended. So it may not be, I don't think, if you can do what you're being asked to do and get to us, I wouldn't have any problem with it getting out. And we may be saying the same thing anyways, because if you do need time or we're not clear on it, we're going to ask for more time anyways.
Yeah, so if I can take back the understanding then that, if 90 days is the preference of the legislature, we're certainly willing to work with that. But again, as the staff recommendation includes this a waiver of that, so that if in fact we're ready to go, 30 days, 45 days, even before then we would have a proactive process where we get that approval and then go on from there.
Right. We're saying that's what I'm trying to say is if you can get it done and we're okay with it, then you'll be fine. It's not as if we're going to hold you up just because we want the 90 days. We just want to make sure that we're all on the same page and we're comfortable.
And
if we need the extra time, we're going to ask for it anyways.
And I would just ask that as staffers and LAO draft the language that include that understanding.
It's fine.
Your second issue was with regard to the trailer bill language. We have provided staff with a high-level summary of what the TBL does propose to include. As I understand it, the staff is recommending that we adopt these as concept that would then provide your staff and others a chance to review it in more detail for formal action later. And we're okay with that.
Good. All right.
Okay. The third item is with regard to the analyst's recommendation for a lower cost fiscal alternative. By way of background, the outcome from our fit gap is to have the three vendors produce compliant bids for the system. But given the fiscal situation facing the state, as I understand that the LAO wanted the fit gap vendors in the project to not only propose or provide for the full solution, but some scaled-back solution that might be less costly. And here again, I think the project is comfortable with going there if the options are involving reducing cost. But my concern is that the way it's presented in the agenda as well as the LAO's write-up is that it offers the only way of reducing cost is to scale back scope. And what I'd like is for some flexibility to look at other options for reducing costs other than just simply reducing scope. For example, this is a very, very large IT project. There could be different ways in which to do the IT infrastructure, whether it be the data center or those sorts of backbone components, that would be less costly one way versus another. And if that's the case, you may be able to get a lower cost solution, but not necessarily impact scope. And so I have the flexibility to do that. In addition, as the legislature considers, cost reductions with respect to a different alternative, we need to keep in mind, too, that the different alternative could have a different benefit stream, so that you may have a solution that's really, really inexpensive, but you won't be able to deliver any of the anticipated benefits from fiscal. So I think it has to be more a wider and more comprehensive evaluation than simply a lower cost, lower scope going forward with that. So I just would like to have that flexibility going forward as we craft that other option.
Comments from the LAO?
Yeah, as we did recommend earlier, we think there is some merit in looking at potentially reduced scope. But we appreciate what the project has said there, that there's other things besides scope. And we always thought, to the extent the vendors were going to come back with the reduced scope, of course it would include a discussion of benefits. It wasn't a one-sided look. So I think with that we're in agreement. We do want to add, though, that when we made the recommendation, that was before the RFP, the request for proposal, was on the street. Now that it's out, I wouldn't say we're now against potentially this, but we do have sort of a pause, a little concern over sort of the legislature enacting trailer bill after an RFP is out. I think also there's probably some room for this kind of informal discussion to be going on. I think the project has some understanding about the legislature's ultimate concerns, and I think even with some flexibility, maybe short of trailer bill, I think they can put a good package in front of you a year from now.
I think that's a point well taken. So I guess the way to say that, and correct me if I'm wrong, is that we're okay understanding, obviously we're looking for efficiencies in scope, but it's under the legal requirements of you've got a request for proposals out there, obviously. So,
yeah, I think what the project is since we've had a chance to dialogue with ledge analysts, the first benefit is that we have some clarity that there's some flexibility about different approaches. The way that would actually implement this recommendation, Senator, is by issuing an addendum to the RFP on the street that would ask vendors to come up with a different cost, a different solution, in addition to the one that they would ordinarily propose. And that would be done via the addendum process. I believe that we could do that within the current structured procurement because this is a two-stage procurement. It would not affect, I don't believe, our award of the 3 fit-gap vendors. We get them in place, they come on board, and they start to learn about the state's processes, and say within 30 to 60 days, we issued the addendum asking that they produce that other alternative. But again, it will be an alternative in addition to the full scope solution.
I guess the two things that come to mind for me is the legislature and this committee will still want to see what that is. Mm-hmm. So we want to be consistent with the RFP.
Correct.
And given our comments about your concern about this dragging out too long, I assume that's why. I mean, you don't want to go from 60 to 90 days, but we also don't want to do the same thing by having an addendum and also clouding the requirements. So somewhere in there seems there's a common sense approach that will still allow the legislature that appropriate review that doesn't open up the whole RFP.
Right. And we can work with the analysts and staff on the appropriate mechanism for ensuring that happens.
All right. Don't confuse us any more than we will be anyways.
Okay.
That's never mind. Okay.
We try our best.
All right. So with that, we're comfortable with the interpretation of the 3 recommendations. Okay. Finance, anything? You okay? All right. So that'll go out 2-0. Thank you. Okay. Thank you for your time.
Okay.
That's our last agendized item, and we'll go to public comment. If there's anybody here who would like to speak, knowing that the item on the Williamson Act is something that's not on the schedule, but Senator Harman has brought up. Welcome back.
Thank you very much, Mr. Chairman. Kathy Mannion with the Regional Council of Rural Counties. At a previous hearing, you were gracious enough to allow about a dozen organizations composed of agricultural organizations, local government, and conservation and environmental organizations to bring the issue of Williamson Act before you with a request at that time that some level of funding over $1,000 be acted upon by the subcommittee so that the issue could go to conference committee. And we're here again bringing that request forward. Appreciate it.
I appreciate it. Any other comments?
Mr. Chairman and members, John Gamper, representing the California Farm Bureau Federation. I think it's interesting to note in on page 3 of Agenda A, the homeowner's property tax exemption, one item, ironically, above the Williamson Act, $442 million. If just 1% of the Williamson Act land comes out at 5 units to the acre, and those are built to owner-occupied houses at $70 per house, that would be $57 million. If 10% comes out, it would be $575 million. So clearly the investment of $28 to $38 million in the Williamson Act is going to save the state money in the long run from having to pay the constitutionally mandated homeowners property tax exemption. So we'd urge, as Ms. Mannion said, an appropriation of something larger than $1,000 to show the legislature's support for the program.
Thank you. Appreciate your comments. And it's not on our agenda today. We're not unsympathetic, but in the vast world of negotiations around here, the negotiations will continue as appropriate by others. So thank you for coming.
Thank you.
With that, seeing no one else, we are adjourned. Thank you.